Alrighty, we got about 15 people here, 8 from over on Twitter and 7 over here on X. So I'll get us started. We jumping right back into golf's closing argument. Hey y'all, guess what? I got that tooth fixed. I feel like a new
Place
person.
on the record. One moment, John.
Sorry, Mr. Goff.
No, you're good. You're good. I'm not using any of that stuff. No, protesters, whether they were the Black Panther group or some other group, were behind the barriers in front of the courthouse. There was a truck carrying a coffin with the names of the defendants on it. At least one of these groups, I believe it was the Black Panther group, is referenced in the motion filed this morning that their specific objective was to influence the proceedings in this case. I don't know whether they intended to scare the defendants, but I have co-counsel with a small child who was scared to death. Large weapons, apparently automatic weapons, were seen outside the courthouse. And, given everything else that's already transpired in this case, we believe at this point that it's appropriate for us to renew the motion for mistrial. This court has gone to great lengths to give these defendants a fair trial. But the security precautions that were in place, despite the sheriff's best efforts and your honor's best efforts, we've now got people who claim to be violent driving around the courthouse with coffins with our clients' names on them with semi or fully automatic weapons. I mean, I'm not sure that this is no longer a figurative mob. This is a literal mob. And inevitably the proceedings, despite best efforts are taken, we would move for mistrial.
Anything more in defense?
Go.
Our position again is if the jury has been exposed to it, yes, we would be gravely concerned and we would need them to let the court know that they've seen it and it's had any influence on them. Short of that, if it's folks exercising their First Amendment rights outside and our jury is unaware of it, then we're okay.
And I would agree with Mr. Hogue. That's what I was going to say.
So, yes.
And I would, one more thing. To make sure in this most important trial that the jurors are not being exposed to these matters, I would ask the court to affirmatively question them altogether, to remind them, to bring it to your attention or the court deputy's attention if they have encountered it or been contacted in any way.
State asks that you deny the motion for mistrial. We leave it to the discretion of the court.
The court's again denying the mistrial. I've indicated previously and mentioned to counsel that I agree with the concern that is out there with regard to the jurors having exposure to anything that may be going on outside. Whatever may be going on outside, it has not been brought to my attention on a security level. Again, individuals have a right to be outside the courthouse. I agree with Mr. Hogue that the court needs to keep a very close eye on whether or not whatever may be going on outside the courthouse has any influence upon the jury, and the court has taken steps to ensure that the jury is insulated from anything going on around the courthouse so that they can focus on their business before the court, which would be to consider the evidence presented as well as the arguments of counsel, and I will continue to endeavor to do so.
Has the court talked with the jury bailiff at all, and also keeping lines of communication up with the jury bailiff so that she would say, Judge, there's some murmurs or there's some things being spoken? Is she keeping an active ear out for the court?
Without getting into detail, I will tell you that the court I'm trying to stay apprised of whatever may be going on with the jury. As far as what's going on outside, that's up to whoever's outside making sure that everything's okay. But as far as this jury is concerned and what may be going on that may affect the proceedings in this courtroom, yes, I have tried to ensure that I'm at least aware of anything that may be important enough to affect the proceedings. And if something did happen, I would probably be bringing it to everybody's attention because I think it would be important for counsel to know.
One other thing, I wanted to move again that we replace juror number 12. And I will tell you, I tried to make some eye contact with her during my closing. She had nodded off. She was done. She was sleeping. And so at one point, I walked closer to her to try to rustle her up. And I even think, thought there was someone that might have even moved her chair, kind of kicked it, and she then still nodded back off again. So I would ask again, since this is now about the third or fourth time that we've had to deal with it, that we have her replaced with the first alternate.
We would join that.
Jury 12 is sitting right in front of me. I never saw this. Her chair, eyes open.
So Ms. Duncan's talking about what she saw, so let's
This
let
is
her
what I
finish.
saw. And I was facing Ms. Hoag while she was talking, but I was very closely watching the jurors. And Jury 12 was right in front of me. I did not see her nod up. I didn't see her close her eyes at all. I saw her actively paying attention to this. That is what I saw.
Okay, I will again start focusing on juror number 12, who I think is sitting close to the bailiff now, and make sure.
And for the record, Your Honor, is there anyone else at the council table that's able to indicate whether you agree with what I saw? I thought that you and I had made some eye contact. I must have misunderstood that I thought you were looking straight at her.
Yeah, I apologize. I didn't mean to interrupt Ms. Dunikowski. I did see it. There were 2 times where I thought about turning over a box accidentally or kicking the table hard, but I didn't want to interrupt her, Ms. Hoag's closing, but there were 2 times.
I'm hearing a couple different things, so I'm going to keep an eye on juror number 12 again and ensure I did not see a juror sleeping during closing arguments. But that, of course, is something, particularly with what has happened previously, that I now will again start keeping a close eye upon.
Thank you.
Your Honor, he was nodding off during his Hope's presentation. I mean, she may need medical attention. We may have a coma here before I'm done.
Let's get going.
Okay, with that, we're recessed. Let's go back to 10 minutes.
So rise for the jury. Please seated.
All right, ladies and gentlemen, welcome back. I'm saying we are ready to proceed with closing arguments. Mr. Goff.
When did Roddy Bryan know the McMichaels brought guns? When did Roddy Bryan know Travis McMichael would shoot Mr. Arbery? And at that point, what could Roddy Bryan have done to stop it? The inconvenient truth is that Roddy Bryan did not know and could not know that these men were armed until moments before Mr. Arbery's tragic death. He did not know and could not know that Arbery would be shot. And by that time, sadly, there was nothing Roddy Bryan could do to prevent this tragedy. Roddy Bryan didn't shoot anyone. At the time of the shooting, he was some distance back. He was armed only with his cell phone. Isn't it time, ladies and gentlemen, that we send Roddy Bryan home? Roddy Bryan fully cooperated with the police. He's given several different statements. He's provided the now famous video that you've seen so many times and probably will again before we're done. Roddy provided his cell phone multiple times. He signed all kinds of consent forms. He gives them access to his truck. He gives them the night owl videos from his house, the videos that had been overlooked in the canvassing of the neighborhood because he was down at the police station. He gives them his social media. He gives them his Facebook. Ladies and gentlemen, without Roddy Bryan, there is no case. You will have to decide what justice looks like between the McMichaels and Mr. Arbery, between the McMichaels and the Arbery family. But the reason that you can do so, the reason that we can have this trial is because of Roddy Bryan. Roddy's decision to cooperate with law enforcement to help them discover the truth about the events of February 23rd, 2020, is not the product of slick lawyering. And had no lawyer on the side of the road in the minutes after Ahmaud Arbery was shot. It was not some lawyer. It was Roddy Bryan, without any lawyer, without any help, without any assistance, making that decision on his own. Roddy Bryan made the choice. Roddy Bryan decided to invite Officer Minshew to sit with him in his truck, even before Roddy Bryan has a chance to look at the video himself. All this again without a lawyer. These actions, ladies and gentlemen, demonstrate good faith. His conduct negatives any inference of criminal intent. Who is Roddy Bryan? Roddy never served his country like Travis McMichael. Roddy never served his community like Greg McMichael. Roddy is a quiet man. Roddy repairs small engines at the local hardware store. Roddy knows most of the English language, or so he believes. Roddy Bryan keeps to himself. His neighbors don't really even know who he is, even though he's lived in the neighborhood for 3 years. Roddy is not boastful or a braggart. He is not loud or boisterous. He is not an attention seeker. Roddy tries to avoid bad language, not always successfully. Roddy is respectful. He's an ordinary guy, a regular guy. Roddy Bryan is no vigilante. There's no evidence of that. Roddy isn't running around Sapilla Shores with guns, openly carried in broad daylight. He didn't even bother to report the theft of his own trailer. After all, it's just stuff. That's what insurance is for. The Amish have the saying, what you take into your hand, you take into your heart. Roddy Bryan grabbed his cell phone. That's not intended as a comment upon anyone else, but that's just who Roddy is. What else does the evidence tell us about Roddy Bryan? Is Roddy Bryan the smartest guy in the room? Is he like some kind of rocket scientist? In these interviews that Mr. Bryan gives to the police, is there some clever wordplay like Mr. Bryan is smarter than everybody else? Is that what the evidence suggests in this case? The evidence suggests that Roddy Bryan legitimately struggles to find the right words, that Roddy struggles at times to convey the meaning, the truth behind those words. There is no evidence that he is a wordsmith. No evidence that Roddy was playing word games with law enforcement officers. He simply can't find the right words. The evidence in this case shows that context is key. If you honestly seek the truth here, which is your duty as jurors, if you listen carefully, you will see that what Roddy Bryan means, as opposed to simply hearing his actual words, it is clear that he never wished to hit Ahmaud Arbery. Why the prosecution felt it necessary to phrase the things the way they did in their opening statement, Ms. Dunikoski will have to answer to you for. I was unable to play it earlier, but we are now going to try and play the excerpt from the interview with Mr. Lowry, specifically that most damaging part of his statement, where he supposedly wishes that he had hit Ahmaud Arbery.
You said that you had handprints on the truck where the guy was trying to get into it.
No, I feel pretty sure that's what he was doing. I mean, I can't say for sure that he was up there. He went on the door. I didn't give him a chance to get to the door. But after I angled him off the side of the road, and I kind of went on past him because I didn't hit him, which I would have. Might have took him out and shot. But I probably got past him a little bit, and he come up on me, and I could see him in my mirror, and he was coming for the door. And I seen his hands on right behind the door.
Ladies and gentlemen, in the video, as opposed to the officer's testimony, you can see Mr. Bryan's demeanor. You can see his gestures and his mannerisms. And you can see that when he says that he wished he hit Mr. Arbery, he said that just after he says that he didn't hit him, and he's expressing regret because Mr. Arbery has died. And maybe if he hadn't gotten down where he was, he wouldn't have been shot. That is much, much different in context than to suggest that Roddy Bryan wished that he had hit Mr. Arbery. That's a reflection of regret that Mr. Arbery was hurt by the McMichaels. That's certainly not a suggestion that he bore any ill will. And how many other instances of that do we have in this case? How many other times has the district attorney's office fired cheap shots at Roddy Bryan? How many times have the GBI taken cheap shots at Mr. Bryan? And in the end, you may wish to ask yourself why. Now, in the defense case, and we didn't do it, we promised we wouldn't, but it's clear that Mr. Bryan did not wish to strike Mr. Arbery, that he never had any intention of hurting Mr. Arbery. He never said anything to the contrary. The evidence will show that he had no knowledge, no reason to believe that anyone else out there meant to hurt or shoot Mr. Arbery. If they had a secret intention or desire to do that, it could not be known to him. Now, there is another excerpt that I want to play from the Minshew video. Only one, Okay. Because again, I think it shows you Mr. Bryan's demeanor. It has been suggested by the state that much of what Mr. Bryan says later is somehow an after the fact rationalization of what happened that day. But when you listen to this, I think you'll see that the truth of what Mr. Bryan is trying to convey hasn't really changed. Obviously, there's a reason we all don't play more of these. Go ahead.
What did it look like he was trying to do? He was trying to get on this side of the car, right? What did it look like he was trying to do?
I mean, I cut him off pretty good now, but I mean,
He actually pulled your handle?
I won't be surprised if that's his marks right there.
Okay.
He was trying to get to the handle.
Okay.
Yeah.
All right. Did nobody got us on video? You just witnessed it,
Yeah,
right?
I got it.
You got it on video?
Make it look better. Okay. You ready?
Yes, sir. Yeah.
You want
At what point did you start videoing?
Well, I thought he was gonna get away.
Okay.
So that was
You was trying to capture who he looked like?
Yeah, I mean, to be honest with you, I probably got 2 videos, 3 videos. I mean, it probably
Okay.
started over here. I don't know what I got because half the time I was trying to drive.
It was suggested that Roddy Bryan made up the idea that he was trying to preserve Mr. Arbery's identity, that he was trying to preserve it because he thought he was going to get away. It's been suggested that that's not what was going on. But yet, here on the side of the road with Officer Minshew, Roddy Bryan says within minutes of the shooting that that's exactly what he was trying to do. We have one video in this case. Well, we have 2, a shorter version of the one you've seen. But when Mr. Bryan is talking with Officer Minshew, he hasn't had a chance to look at his phone. He hasn't had a chance to see what he has. He thinks he has 2 or 3 videos. He thinks he's caught much more than he had. Now, either you believe that Roddy Bryan is the smartest person in this room, that he's playing games and manipulating the police from the moment this has happened, or you know that Roddy Bryan had good faith from the start, that he tried as best he could to help the police. Maybe it would have been better if he had been able to record more, if he knew better how to operate his phone. But the idea that somehow Mr. Bryan is quote unquote minimizing his involvement in this case, had he recovered as much video as he thought he had, he might have had the whole thing on video. And he's giving it to the police. He's inviting Officer Minshew to sit with him in the car, to look at it with him for the first time. Not with some slick Cobb County lawyer, by himself. That tells you that Roddy Bryan is not guilty. Because unless you think he's smarter than everybody else in this room, that he's smarter than all these police officers, that he's smarter than the cream of the crop, the creme de la creme of the GBI, then you know he's trying to tell you the truth. He just can't always find the words. And to hear, again, all this stuff about Mr. Bryan, about all these things that happened, we'll come back to that later. But when you look at the Lowry interview, when you look at Mr. Minshew, the Minshew discussion on the side of the road, you know what the truth is here. Now, if I'm out of order, I'm sorry. But again, as I said before, the events of this day from Mr. Bryan's perspective are chaos. Mr. Bryan doesn't know what happened up the street at the English residence. He doesn't know Mr. Albenzi is out there. He doesn't know Mr. Albenzi's called 911. He assumes somebody's called 911, and he was correct, but he doesn't know. He doesn't know that Mr. Albenzi is armed and just up the street. Mr. Bryan is not in communication with anyone prior to the shooting, not Mr. Albenzi, not Diego Perez, not Gregory or Travis McMichael. At times, as you've heard, Mr. Bryan feels like he's alone out there with Mr. Arbery, and it scares him. Roddy Bryan doesn't see any guns until moments before the shooting. We'll come back to that. I think, if I recall correctly, the testimony was, although you can see, and you will see in a moment, Greg McMichael standing in the back of the pickup truck in the moments before the shooting, Mr. Bryan, on that day, doesn't even recall Gregory McMichael being in the back of the truck. He doesn't realize Gregory McMichael's in the back of the truck until later, until afterwards. Roddy Bryan thinks that it takes the police several minutes to arrive on the scene when we know it was mere seconds. Roddy gets so many basic facts wrong, so many key facts. Is it any surprise that months later he would struggle to recall details of what happened that day when he couldn't recall big, obvious details right at the time it happened? Let me shift gears for a moment. Closing statement is sometimes referred to as closing argument. Let me assure you, I don't want to argue about you with the evidence. First of all, there's 12 of you. There's only one of me, and you get the last word. Second, lawyers, we tend to remember things, frankly, sometimes the way we wanted them to be or the way we expected them to be, whereas you hear it as it actually comes out. So if my recollection differs from yours, I would trust your collective memory. And I'm not supposed to say this, okay? We're all taught never to say this. But what we say as lawyers is not evidence. The evidence is what you heard. And if something I say doesn't ring true to you as what the evidence is, you don't have to wait for someone else to object. I don't want you to consider something if you don't remember it as the evidence. Now, before proceeding any further and before I forget, I do want to express my gratitude to Mr. Bryan, to the court, to my distinguished opposing counsel. As I walk through the front doors of our courthouse every day, I am reminded what an honor and an absolute privilege it has been to come before you. What I'd like to do now is go back in time. I want to take you back, if you can join me, to the morning of February 23rd, 2020. It seems, at least to me, both so very far away and yet like it was yesterday. It was a time to which many of us might wish to return, if only we could turn back time. Ahmaud Arbery is still very much alive, perhaps still asleep. Some of us, like Brooke Perez and her husband Diego, have gone off to church. Others read the Sunday paper. The politically minded may recall Bernie Sanders is the front runner for the Democrat nomination. The sports-minded may recall that the Daytona 500 had been held a week earlier down the road. Donald Trump was the grand marshal. And our local newspaper, the Brunswick News, covers school events celebrating Black History Month. You may recall COVID-19 is still a mystery. It's a China problem, an Italian problem. Some guy we've never heard of, Dr. Anthony Fauci, warns us that we should conserve the already dwindling supply of masks for first responders and for healthcare workers who most need them. But Roddy Bryan isn't reading the Sunday paper. Roddy Bryan is not in church. And he probably isn't paying much attention to the corona. Roddy Bryan is working on the front porch of his home. After renting for several years, Roddy and his fiancee have just purchased their home on Burford. As a small engine repair guy working at the local hardware store, this is a big deal for Roddy. And he isn't going to waste any time before fixing it up. When you think back, it was a different world, but it's the world in which these events take place. And it's in that context that we have to look at the evidence in this case. Now, I think we have the first Night Owl video. I call it the first Night Owl video, the porch video. I think we played it for you once before. Here you can see Roddy Bryan standing on his front porch, trying to repair a column. He is listening to music. The music is playing in the garage. The door is open. We've seen that from the previous picture. You'll see the moment his truck is out front. If you look carefully, I believe you can see his hammer on the ground behind him. And I believe other tools as well. Now, we'll stop that. Now we have a still photo, which we're about to turn back on. The still photo. Sorry. Beggars can't be choosers. I'm going to wait on this part. This is the front of the Bryan residence. You have to add in Mr. Bryan on the porch. You have to add in pickup truck in the driveway with lumber in the back. You have to imagine, if you will, the music playing. It's probably playing loud because his hearing's not so good. Is there anything threatening or menacing about this picture? Is there anything threatening or menacing about this image? Or is this something we'd expect to see in a Norman Rockwell painting? We talk about driveway decisions. Mr. Arbery has driveway decisions that he's making this morning. I'm not going back into all that stuff with the Englishes and Diego Perez and Matt Albenzi and Robert Rash. That's already been covered. And although Mr. Bryan may well have read about it on the Exit 29 page. He doesn't recall it, at least on this day. But Mr. Arbery is now running down the street, running from the English residence. He's passing house after house after house on a nice Sunday afternoon. Is there any evidence that Mr. Arbery sought help, sought assistance from anyone in that neighborhood up to this point? Maybe you heard it. I did. But as he comes up to Mr. Bryan's residence, he starts coming by his house, why isn't Mr. Arbery asking for help? Why isn't he calling out, hey, somebody call 911. There's crazy people after me. Maybe that's because Mr. Arbery doesn't want help. Now, Mr. Bryan spots Mr. Arbery out of the corner of his eye. Roddy Bryan knows the joggers in the neighborhood. On his end of the neighborhood, let's be clear, it's a big neighborhood. There's 4 or 5. Ahmaud Arbery isn't one of them. Roddy Bryan's never seen Ahmaud Arbery before. Roddy Bryan intuitively, and that's the word for it, intuitively, knows the difference between someone running to something and someone running from something. But that mystery is resolved pretty quickly when the white pickup truck that he does recognize from the neighborhood comes by. Now, Roddy Bryan doesn't know Travis McMichael. He would recognize Greg, but Greg McMichael is sitting on a car seat, probably with his head stuck up somewhere in the bed liner. Roddy Bryan doesn't realize Greg McMichael's in this truck after the tragic shooting.
Objection. It's not going to object to facts, not evidence. None of this came in at all before this jury, and we would object to anything about Roddy Bryan and knowing Greg McMichael or anything.
I'm pretty sure that he specifically said in one of the interviews that we went through that he didn't realize Greg McMichael was in the truck. But the jury knows what the evidence is, and their recollection controls.
Let's stick to the evidence as was presented to the panel.
Thank you, Your Honor. At the time that Mr. Bryan looks out, he sees Mr. Arbery in the truck. He sees them side by side. He cannot, because of the music, he really can't hear the words. I believe the testimony is he's basically reading the lips of what turns out to be Travis McMichael. He can't see Mr. Arbery's lips. He can't see what, if anything, he's saying. Mr. Bryan has told us repeatedly that he's never heard Mr. Arbery say anything from the beginning to the end. So at this point, it's clear that Mr. Arbery does not want help from Mr. Bryan. It's clear that he goes ahead and runs off. And at that point, Mr. Bryan has to make a decision. Now, there's been some testimony. I think Mr. Bryan said that he called out to them, "You got him," which would be consistent with what he's seeing on the road. But nobody else hears that we know of. We know another witness said that they didn't hear it because they testified. And we're going to play a second Night Owl video that we didn't play previously, where you see Mr. Bryan coming off his porch. Now, I'm going to suggest to you, and you will have to decide what the truth is here, that when Mr. Bryan says he called out to them, did he? Do you see that on either of these videos? Do you see it on the third one to come? Again, is Mr. Bryan relating what actually happened or what he thinks has happened? Is Mr. Bryan's mind playing tricks on him? In any event, Mr. Arbery goes down the street. Now, Mr. Bryan, at this point, we're going to go to the next Night Owl video. Sorry, you went too quickly. There he is. Okay, watch carefully. Mr. Bryan has said on some occasions he walked to the kitchen. On another occasion, he said he ran to the kitchen. He said he walked back out to the truck. Another time, he said he ran back out to the truck. Well, what we know from this video, it takes 13 seconds to get from the edge of the driveway into the kitchen to reach the keys and go back out to the truck. Mr. Bryan is, in fact, walking calmly to the kitchen and walking calmly to the truck. And his recollection of doing otherwise is faulty. Now, we also know, as Mr. Bryan pulls out, and by the way, we also know that he left his rifle in the house, left a hammer on the porch, and went out with his cell phone. Now, here we see when Mr. Bryan initially pulls out, Mr. Bryan is pointed to the right. Now, he backs up. Now, it's at the very end, he backs up and he straightens out a bit. Whether Mr. Bryan said he was going to the left or the center or slightly to the left, the actual evidence in the case is consistent with him pulling straight out. And again, we know from all the other things that we've seen that Mr. Bryan's recollection of events that day simply isn't that good. Now, Mr. Bryan makes what is for him a very faithful decision. He actually pulls out in the road. Now, at one point, he says he overshot the road. Another point in the same interview with Detective Lowry, he says that he crept out onto the road. The state suggests that Mr. Bryan either hit Mr. Arbery or tried to hit him and pushed him with his 5,000-pound motor vehicle. We'll come back to that in a second, but I just don't think I think the evidence is inconsistent with that. Now, I do want to talk about the indictment for a minute. Thank you. Let's take a minute to review the indictment. It is what we sometimes call a kitchen sink indictment. Everyone, all three defendants are charged literally with everything in the indictment, every crime set forth therein. You may find this confusing and difficult to sort through at times, since the factual bases and underlying legal bases for the 5 murder counts are so closely intertwined with one another. However, this is perfectly acceptable. There's nothing improper about it. Murder is murder. Each of the remaining 4 counts of the indictment, aggravated assault with a shotgun, aggravated assault with a motor vehicle or motor vehicles, false imprisonment, and attempted false imprisonment, actually serve as predicate felonies for the felony murder counts. In other words, this indictment does not allege any offense against any defendant other than murder and the predicate offenses for murder. There are a couple of legal principles I feel obligated to go over in every case. One of those is reasonable doubt. Now, you've already heard several very capable lawyers go through that, so I'm not going to spend a whole lot of time there. Without belaboring the point, however, I would refer you to what I consider the core principles at the heart of the court's charge on reasonable doubt. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. If you are a fair-minded, impartial juror honestly seeking the truth, and you've certainly given us every reason to believe that you are, if at the end of the evidence you have a doubt, that is a doubt upon which you may acquit the defendant. A reasonable doubt is a doubt based on common sense. It is a doubt for which a reason can be given. If you can give a reason to doubt whether Mr. Bryan is guilty, then your mission is complete. And at that point, you should acquit Mr. Bryan. Now, I also often use this provision lifted from Robert Bolt, A Man for All Seasons, when I talk about reasonable doubt, because I find it helpful. And let's be clear, it is not a statement of the law. It is the principle behind it. Some of you may be familiar with the play and the movie. Some of you may not. William Roper asked Sir Thomas More, so now you give the devil the benefit of law. Sir Thomas More says, yes. What would you do? Cut a great road through the law to get after the devil. William Roper says, yes, I'd cut down every law in England to do that. Sir Thomas More replies, oh, and when the last law was down and the devil turned around on you, where would you hide, Roper? The law is all being flat. This country is planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down, and you're just a man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil benefit of law, Sir Thomas More says, for my own safety's sake. And when you apply the reasonable doubt standard, remember that standard, that legal principle, isn't there for Roddy Bryan. It's not there for these other defendants. It's there for all of us. And it's a principle that we cannot forsake. The court's going to charge you, I believe, without trying to put words in his mouth, on parties to a crime. The provision that's relevant to Mr. Bryan in this case is the second one. To be a party to the crime, Mr. Bryan must intentionally help in the commission of an offense, of a crime. Mr. Bryan cannot be a party to a crime by accident. He can only be a party to the crime intentionally. And we'll come back to that principle again. Now, count 1 is murder. And I don't want to tread over the same ground that other counsel have tread, but the issues are somewhat different for Mr. Bryan. I hesitate even to respond to count 1, because by doing so, I don't want any of you to think for a moment that there's anything here even worthy of a reply. but I am required to do so. Roddy Bryan didn't shoot Mr. Arbery. He was armed only with a cell phone, and he was a good distance away when the shots rang out. Roddy did not cause and could not cause Mr. Arbery's death within the meaning of this statute. Roddy was not the shooter, so he could not shoot Mr. Arbery unlawfully. Roddy did not shoot him at all. Roddy Bryan acted in good faith on the day in question. There is no evidence whatsoever of malice. And most importantly, and I think this echoes arguments made by others, nor can Roddy be a party to the crime of malice murder, because there is no evidence that Roddy Bryan intentionally helped Travis McMichael murder Mr. Arbery. Where is that evidence? And that takes us back to the three questions I asked a moment ago when I first stood up. Roddy Bryan certainly was not aware of any intention on the part of Travis McMichael to shoot Mr. Arbery. And I'm not saying he had that intention. You will have to decide what Travis McMichael did or did not do. But Roddy Bryan certainly was not aware of any such intention and certainly could not be a party to the crime of malice murder because he can't intentionally help commit a crime he doesn't know is underway, doesn't know is contemplated. At this point, we're going to try and go back and play the video again, the famous video. But I'm going to repeat the three questions that I started with. When did Roddy Bryan know that McMichaels brought guns with them? When did Roddy Bryan know Travis McMichael would shoot Mr. Arbery? And at what that point, what could Roddy Bryan do to stop it? We ready? All right. Now I'm going to try and keep up with this video. At 0.03 seconds into this video, Mr. Arbery turns around on Holmes. Now, stop. What I want you to do is not so much look at the video at this point. Listen with your ears to the noises in the background because they tell you what's really going on, even when what you see on the screen is unclear. At 0.04, you'll hear Roddy Bryan tap the brakes. He's still in drive, and you'll see he's going at approximately 2 miles per hour. I could see. Can we stop it? Yeah, let's try that again. It's very, very difficult to get this video precise. Yes, we're looking for 4 seconds. We're looking for the speed on the speedometer. Okay. Well, what you can see is that Mr. Bryan you hear him tap the brakes. You hear Mr. Bryan tap his brakes, but he's still in drive and he's going about 2 miles per hour, which is about the same speed that Mr. Arbery is moving. He's been described as chasing Mr. Arbery, as hunting Mr. Arbery, as attempting to run Mr. Arbery down. But what you see on the video, and there is you can see that Mr. Bryan is moving at approximately 2 miles an hour, and you can see that the seatbelt is not in place. Now, at this point, we're going to go ahead and play it to about the 17-second mark. Listen for the gear shifts. I'm sorry, it's not there yet. Go ahead. You can see Mr. Bryan's foot is not on the gas pedal. Now, you hear a motor vehicle go by. We can guess which vehicle that is, but we hear it pass. And then at 20 seconds, we're going to hear the seatbelt alarm go off. Now, at 26 seconds, you can hear the transmission shift as Mr. Bryan puts his truck in park. And then 2 seconds later, you'll hear Mr. Bryan buckle his seatbelt. Now, at about 30 seconds, and I'm going to go through this with you before we play it so you'll know what to listen for. Mr. Bryan utters the famous words, "I'm gonna keep going." And you'll notice that his cell phone is down. This is where he says, "I'm going to keep going." And the state is suggesting to you, if I recall the opening statement and the opening portion today, that this is where Mr. Bryan is turning around to give chase to Mr. Arbery in the moments before his death. But if you listen carefully, I think you'll hear a somewhat different story and a different truth.
You know what? Don't keep going.
Mr. Bryan says, "I'm going to keep going." He's put the car in gear. But if you watch, you'll see Mr. Bryan isn't going back towards Mr. Arbery. He's not going back towards the McMichaels. He's going in the opposite direction. And he starts at a high rate of speed. Here, the wheels lose traction slightly. Now, you can't see it, but he's not moving towards Mr. Arbery. He's moving away, and you'll see why in a moment. Now, here you can see the speedometer is, at this point, he's slowed back down. He's at 4 miles an hour at the 51-second mark. And shortly after this, you hear him put shift the transmission again. And I think you'll see it's clear from the context, which is a K-turn, that he is putting the truck into reverse. And then a few seconds later, he puts it back into drive. This is the K-turn near the top of Holmes that you see on the reenactment video. Top of Holmes near Zellwood. Go ahead. When I start the video up, when we start the video up, it's a team project here. When we start the video up, listen for Mr. Bryan's breathing. I think when you hear his breathing, you will hear something different than the state has suggested. Now, I can't tell you how to interpret it, but what I hear is someone who is labored breathing, breathing as if he was in fear. Also, around the same time, watch Mr. Bryan's leg, which is momentarily visible on the gas pedal, and see whether you don't agree that Mr. Bryan's leg is literally shaking. Now, he's not driving a Cadillac. I'm sure there's vibration in the vehicle, but if you watch his leg in relation to the rest of the car, to the rest of the truck, I think you'll agree that Mr. Bryan at this point is shaking. All right, let's try that again. Very good. Did we play the right portion there? Or did we miss it? Okay. All right. At this point, Roddy Bryan is looking back down Holmes. Now, what does he do here? He's pulled up his cell phone. His cell phone's been down because he was driving away. When Mr. Bryan said that he was home, when he said the guy didn't want to be caught, that's all consistent with this video. Now we can see that he's turned around. The question is, ladies and gentlemen, why is he turning around? Technically, this is the shorter path back to his house. It may be easier to get in the driveway. You can see the bushes in the video out front. Maybe he's trying to document what's going on. He said that's what he was trying to do. Maybe, and that's just me going out on a limb, I'm going to suggest to you that perhaps, and I know I'll get grief for this, I would submit to you that you can call it karma, you can call it fate, I would call it divine providence. Somebody is guiding Mr. Bryan, whether it's a conscious thought process or not. Something is guiding Mr. Bryan down this street to document what's going on. Just like Mr. Bryan's on his porch. Why does he go out? He doesn't know. He gets in his car, he sits out there, he doesn't even know why. He's being guided, whether that's by a God, if you believe in a God, or by some other entity. But do you really believe it's just coincidence or chance? Do you really believe Mr. Bryan is trying to lie or deceive you at this point? But we're going to go ahead and we're going to continue playing the video. Watching the truck that's in the view. Right. Okay. Mr. Bryan is traveling, as he testified, as an agent indicated in the reenactment video, he's traveling at 10 or 15 miles an hour. He's traveling faster than Mr. Arbery. But clearly, if he was trying to hunt him down, he would be going a lot faster. More to the point, at this point, as Mr. Bryan comes around the dog leg, what we're seeing here, I can't be sure whether this is the enhanced video or not, but what we're seeing here in this courtroom with the artificial interior lighting is certainly a better view than Mr. Bryan has actually looking through that phone with the glare and other stuff that's going to be in the car on a sunny day. Anyone who's tried to look at pictures on their phone while they're driving on a day like this understands that sometimes you can't see the phone at all. But assuming that Mr. Bryan has 20/20 vision and assuming that he has every bit as good a view of his phone as he's driving, as you see here, where's Travis McMichael? I can't see Travis McMichael in this picture. Really, honestly, I can't see Greg McMichael in this picture. And I certainly can't see any guns. Now, what's our post on this one? This is at 1:15 into a 1:43 video. And Mr. Bryan at this point has no reason to know that the individuals in that truck have guns. All right, okay. All right, you can still, at this point, I think you can see that there's a shadow, a silhouette of what's Travis McMichael. But from where Mr. Bryan is in his vehicle, again, even if he has a perfect view of his phone, you can't see a weapon. You can't see anybody's armed. All right, we're going to go forward again. At 1:15, now watch, you see that Mr. Bryan's phone is focused to the right of the truck. Why? Because Roddy Bryan doesn't know Matt Albenzi is down on Jones at 220 Satilla with his phone and his gun. The McMichaels know because Mr. Albenzi's given them the hand signal. Mr. Arbery knows because he's run out of the house away from Mr. Albenzi. But Roddy Bryan doesn't know that. Roddy Bryan is thinking that Mr. Arbery, like he has for the last minute or so that he's been out there, that Mr. Arbery is just going to go around the truck like he's gone around the trucks the whole time and head out Satilla towards the exit to the neighborhood. All right, go ahead again. At 1:16, Travis's silhouette should come in view. That's Greg McMichael. Or he passed that. Okay. Now there's Greg McMichael in the back of the truck. Now we know that he has a gun. I think at this point he's on the cell phone. But from Mr. Roddy Bryan's vantage point, looking through this phone as he's trying to drive on a sunny day in his truck, how can Mr. Bryan know that Greg McMichael has a gun or that he's drawn it? He can't. Go ahead. Go to 121, place to 121. All right, this is 121. You can see Mr. Arbery. You can see how far back Mr. Bryan is. And you can see Mr. Arbery going to the left momentarily and way over here, and I promise not to touch the screen. This little fuzzy black thing here, this silhouette is Travis McMichael. Where on this video, putting aside the fact that Mr. Bryan's not going to have as good a view driving on a sunny day in his car, from this video alone, where is Mr. Travis McMichael's shotgun? Roddy Bryan can't see any weapon. He has no reason to know that these men are armed. And at this point, there's 20 seconds left in this video. And we're just going to go ahead and play it. And you tell me, in your mind, because you can't tell me, figure out when Roddy Bryan can see Travis McMichael's shotgun. Because Roddy's looking the wrong way. He's looking to the right, expecting Mr. Arbery to run off. Wow. We're now at what? Where are we on the timestamp? We're now at 128. Roddy Bryan has never seen, and I don't care what is in any prior statement. We know, looking at this video, Roddy Bryan's never seen the shotgun until after it's been discharged the first time. That's not an opinion. That's fact. You're looking at it. You just never looked at it from this perspective before. Let's go ahead and play the rest of it. That's it. All right. Now again, oh, I already had it there. Having looked at the video again slowly from Mr. Bryan's perspective, when did Roddy Bryan know the McMichaels brought guns? I would submit to you that Mr. Bryan doesn't know that there's a gun until it goes off. Not because it wasn't there, but you see what Mr. Bryan is seeing. When did Roddy Bryan know Travis would shoot Mr. Arbery? I would submit to you, he can't know until Mr. Arbery is actually shot. And at that point, what could Roddy Bryan do to stop this tragic shooting? The state has thrown out all kinds of theories. He could have honked his horn. He could have gone to the left. He could have gone to the right. He should have backed up. Well, obviously, if Mr. Bryan saw a shotgun pointing down the street in his direction, he probably would have at least ducked. But he doesn't do that because Roddy Bryan can't see the gun. And when the state tells you that he was hunting Mr. Arbery down, what they're trying to tell you is that he's going down the road towards them when he's going up the road away from them. And when he says he turns around, he brings the video back up. He takes the best video that we have, the only video we have of this shooting. So when Mr. Bryan says on the side of the road on February 23rd to Officer Minshew, I was trying to record what happened. I don't know what I got. I think I got 2 or 3. He only got 1. But fortunately, he got the one that you need to figure out what justice is in this case. And again, it's not for Roddy Bryan. It's not for me to say what justice is here between the McMichaels and Mr. Arbery and his family. That's not our call. That's your call. But again, but for Mr. Bryan, whether you call it serendipity, luck, coincidence, or the hand of God here, not once, but twice, as someone who keeps to themselves, who never gets involved in anybody else's business, who is almost a stranger in his own neighborhood, has now gone out and gotten a video, which is the best evidence for you to look at and trying to figure out what happened here. Now, it's going to come up in different contexts, but the judge is going to instruct you on the principle of abandonment. And it has more than one application here, but basically, if somebody abandons a criminal enterprise, then they cannot be held criminally responsible for it. Maybe you believe that Mr. Bryan was attempting to falsely imprison Mr. Arbery. Of course, that would depend on whether or not the McMichaels were authorized to make a citizen's arrest. We'll talk more about those issues later. But this is a defense, and it is the burden of the state to disprove that defense beyond a reasonable doubt. Under the facts of this case, from this video, as we've just gone through it, how could anyone say beyond a reasonable doubt that Mr. Bryan, having turned away, that he didn't come back for the right reasons? How can one say that he's lied on February 23rd when he says he was trying to get a recording of Mr. Arbery, that he was trying to document what was going on because he thought Mr. Arbery was going to get away and he wanted the police to have that information? Those aren't my words. Those are his words, way back, moments after the shooting. Now, having seen that Mr. Bryan was going away and then turned around and put the video back up, how is that not a reasonable doubt in this case? Now, I don't know what Ms. Dunikowski is going to say, is going to say when she gets back up here. I do know that it seems like every technician in creation has been involved in this case. Drone this, footage that, filter this, enhance that. We got 20 million frames of every second of the footage in this case. But how, in the course of all that work, does someone who's practically computer illiterate figure out that they have this case all wrong? How is that possible? And how do you know that? Count the gear shifts, ladies and gentlemen. The state's theory is that there's 3 shifts, 3 changes in direction. That's 6 gear shifts. They're not audible. We know what happened. And I don't care what Travis McMichael says. I don't care what anybody else says. I'm looking at the video and I'm listening for the changes. You know that when this right here, when Mr. Arbery turns around and whatever Mr. Bryan thinks he's doing with the wheel, I don't see much actual movement. Okay. I see him at 2 miles an hour and then his foot's off the gas pedal. Whatever Mr. Bryan thinks he did, I don't think it was much. But you know that he's driving away from Mr. Arbery at this point because he can't go back and then go back and then go back again because there aren't enough gear shifts. All right, I think we're done with that one. I want to talk to you about felony murder. Now, there are more capable lawyers than I in this courtroom, and they certainly have come up with great ways to analyze all these things that make it simple. I'm just not quite as adept as they are. So if I take a little longer, I apologize. The predicate offenses for the felony murder counts, those are counts 2, 3, 4, and 5, or counts 6, 7, 8, and 9. And I will address each of the underlying or predicate felonies in a moment. But right now, I want to talk about something called proximate cause. Because to support any of the felony murder counts in this case, there has to be a causal relationship to the death of Ahmaud Arbery. And there is no such relationship in this case. Without trying to put words in the court's mouth, I think the court's going to charge you. I'm not there yet. You may find the defendant guilty of felony murder if you believe that Mr. Bryan caused the death of Mr. Arbery, regardless of whether Mr. Bryan intended the death to occur. That's felony murder. There must be some causal connection between the felony and the death. The court, I believe, will instruct you that felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The burden on the state is much greater. The felony must have been directly caused the death, or played both a substantial and necessary part in causing the death. In this case, you may also consider whether any intervening act, those are my words, whether on the part of the McMichaels or Mr. Arbery were sufficient to break the causal chain of events. Actually, I believe both of the lawyers that preceded me for the McMichael defendants have pointed out the error in the state's argument here. Listen carefully to the court's charge. The words "but for" appear nowhere in that charge. They are not to be found. Why? Because "but for" is not the standard. It's too easy a standard. It's too low a standard. It doesn't meet the law. Why? Mr. Sheffield pointed out that but for, I think, Mr. Travis McMichael's grandparents, Travis McMichael wouldn't have been there. Likewise, I would say, but for Roddy Bryan's birth, there's no way that this crime could have taken place under the state's reasoning. You know, the same thing could be said, but for Larry English installing surveillance cameras. The McMichaels would never have known that this was the fellow running by them. But for Matt Albenzi pulling out his wood chipper that day and working in the front yard, he never would have saw Mr. Arbery. But for the actions of Robert Rash and Diego Perez, this incident might not have happened. But for Mr. Albenzi calling the normal police number instead of 911, the police might have responded faster and things might have been different. But for Mr. Albenzi cutting off the Satilla Drive exit, Mr. Arbery might have escaped. But for 100 different things, all of which had to come together in the exact sequence for this tragedy to take place, it could not have happened. So simply saying that but for Mr. Bryan being there that day, that's not the standard. And the state doesn't even try and meet the standard that the court is going to instruct you on. Now, maybe they're just waiting until they have the last word. And all I can say about that is that's just dirty pool. And I certainly hope that's not what's going on. Now, again, with all respect to the state, who has some very capable lawyers, when we look objectively at the events of February 23rd, I would respectfully submit to you that Roddy Bryan's presence is absolutely superfluous and irrelevant to the tragic death of Ahmaud Arbery. Now, that may not be intuitively obvious, but if you think about it, I believe you'll agree. Had Roddy Bryan stayed in bed that day, if Roddy Bryan had stayed on his front porch, would Ahmaud Arbery be alive today? If the state's theory is that these men, and I'm not saying that's the case, you decide what the deal is with the co-defendants, but if the theory is that these men were vigilantes and harbored some ill will towards Mr. Arbery, then what difference does it make whether Roddy Bryan is there or not? Mr. Arbery can't outrun bullets. They've been chasing him for a while, and he's at practically point blank range even before he comes around the truck. The problem is for the state that Mr. Albenzi, thankfully not indicted, not yet anyway, Mr. Albenzi is down the street with his firearm. Roddy Bryan doesn't know that. That's why Roddy Bryan goes down Satilla momentarily as Mr. Bryan is turning up the road. You'll remember the testimony where the state was trying to say that Mr. Bryan was trying to run him over, when in fact, Mr. Arbery had already turned up Holmes by the time Mr. Bryan put his car in reverse. One of them, several times, they incorrectly stated he was trying to run Mr. Arbery over. The reason that Mr. Bryan is continuing down Satilla is he doesn't know that Mr. Albenzi is there. He can't. But Mr. Arbery does, which is why Mr. Arbery is not going to go down that way. Now, my point to you is Mr. Arbery is on foot. The McMichaels are in a pickup truck. We know they circle around all the way up Zellwood to the top of Holmes. How does Mr. Bryan's presence on the road that day, whatever he thought he was doing, okay? Because if the idea is that he imprisoned Mr. Arbery by himself, that somehow, and those are the words he uses, that he cornered Mr. Arbery by himself, I guess, between his truck and the mailbox, I don't know, between his truck and the marsh, I don't know, the state will have to explain the theory to you, but the truck can go a lot faster. Mr. Arbery, if he's superhuman, might be doing 5 or 6 miles an hour, maybe 7. That pickup truck is capable of probably driving 100 miles an hour, maybe 90. Mr. Bryan's presence on the road has nothing to do with the ability of the McMichael defendants to cut Mr. Arbery off. Why? Because even though Roddy Bryan doesn't know it, Matt Albanzi's cut off one of the 2 exits from the neighborhood, and the McMichaels are already at the top of homes. They've cut off the second. Mr. Bryan is not trapping Mr. Arbery. He's trapped the moment the McMichaels get to the top of homes. It doesn't really matter what Roddy does. Now, they do come down the road, and there is a brief time period before the shooting where technically Mr. Bryan is behind Mr. Arbery. But it's clear by this point, it's certainly clear to Mr. Arbery that he cannot outrun the McMichaels. No matter where he goes, they can follow. So again, how is Mr. Bryan's presence on this day in any meaningful way the cause of this shooting? And by the time Mr. Bryan gets around the dog leg, Mr. Arbery is already well within range of the shotgun that Travis McMichael is holding and the handgun that Gregory McMichael has. So if their intention, and again, I'm not suggesting that it's their intention, but if the McMichaels meant harm to Mr. Arbery, if they meant to shoot him that day, what in the world does Mr. Bryan's presence out there have to do with anything? I would submit to you that this is basically all a smokescreen from the state, because Mr. Bryan's presence doesn't contribute in a direct or substantial way to the death of Mr. Arbery, because the McMichaels were certainly capable of catching up with him and shooting him if that was their intention. One more proximate cause issue I want to discuss on these 4 felony murder counts, because it's basically the same issue. And the issue, the principle is one of intervening acts. The judge is going to instruct you that that the causation must be direct and it must be substantial. And although the charge doesn't use the words, essentially it must be unbroken. Anything that breaks the chain of causation prevents a return of a verdict on felony murder.
Objection. Obviously, there's an issue. That is.
Mr. Goff, if we could please, if you were going to make a representation with regard to the law that will be charged to the jury,
yes,
we could remain within the charge that has already been approved by the court and that will be read by the court.
Let me, thank you. Let me go back and make sure I haven't misspoken. The court is going to charge you, I believe, that the felony must have directly caused the death or played a substantial and necessary part in causing the death. In this case, what I'm suggesting to you is that if either the actions of Mr. Arbery or the actions of Travis McMichael or the actions of both contributed to Mr. Arbery's death, then Mr. Bryan cannot be the direct, the substantial, and the necessary cause of that death. What am I talking about? I think it's already been referenced. I could be wrong. I don't want to misspeak. That that Ahmaud Arbery turns in front of the vehicle at the last, the white pickup truck at the last moment, and basically meets Travis McMichael in the front of the truck. We can't see in front of the truck, but we know that's where they are. The question for you is, and I'm not trying to decipher who did what or why, because from Mr. Bryan's perspective, it doesn't matter. It does for yours, but from Mr. Bryan's perspective, it doesn't matter. But Mr. Arbery's decision at that last moment to turn left instead of right, as Mr. Bryan would have expected, as you can tell from the way he's angling his phone, anticipating Mr. Arbery's path of travel. When Mr. Arbery turns to the left, does that not break the causal chain in this case? I would submit that it does. Whether Mr. Arbery is justified in turning and coming at Mr. McMichael or not, that's for you to decide. That affects other people in this case. But Mr. Bryan is not responsible for that. That breaks the chain, the causal chain. It's no longer substantial and necessary. It's no longer direct. Likewise, when Mr. Travis McMichael closes the distance from to the left of the truck as you're looking at it on the screen towards the middle of the truck, or exactly where, I'll let y'all figure that out. But when Travis McMichael does that, regardless of whether Travis McMichael is justified in doing so, Doesn't that also break the direct causation? Does it not also break the substantial and necessary part of Mr. Bryan in causing the death of Mr. Arbery? I would submit to you that Mr. Bryan cannot be the direct and substantial and necessary cause of Mr. Arbery's death. Whether that is the fault, for lack of a better phrase, of Mr. McMichael, the fault of Mr. Arbery, or the fault of both, or simply without any fault on either part, an unavoidable tragedy. Why should Roddy Bryan be held responsible for that? I would submit to you under the law that Mr. Bryan cannot be guilty of any of the felony murder counts for that reason alone. All right, we're to count 6. Count 6 alleges aggravated assault by shooting. Now, we know that Roddy Bryan did not shoot Mr. Arbery. The theory here is parties to a crime. And again, how can Mr. Bryan intentionally help commit a crime that he has no reason to believe is about to take place? When did Mr. Bryan see the gun? When does Mr. Bryan know they're armed? At what point? At that point, what can Mr. Bryan do about it? Again, you've seen from the video that by the time Mr. Bryan knows that the McMichaels are armed, it's mere seconds before the shooting takes place. So the idea that Mr. Bryan's going to get out of his car or honk or yell, stop, we know that's fantasy on the part of the state. What's going to happen is going to happen at that point. Mr. Bryan cannot be guilty as a part of the crime because he can't intentionally help commit a crime he doesn't have reason to believe is going to take place. And he doesn't help. The McMichaels could have shot Mr. Arbery. Had that been their intention, the McMichaels could have shot Mr. Arbery before he got to Roddy Bryan's driveway. They could have done it the whole time. That's got nothing to do with Roddy Bryan. They don't need Roddy Bryan's help to shoot this young man. And I'm not implying guilt or innocence here. It's not my call. That's your call for the other defendants. But what does that have to do with Mr. Bryan? That takes us back to aggravated assault, count 7. I've discussed the physical evidence with you before, the lack thereof, and I'm going to go through that just as quickly as I can. I would note that the state presented no rebuttal evidence during the trial of the case. And so the evidence is the same as it was when we first had this conversation. I would submit to you that Roddy Bryan isn't out there like Evel Knievel, tearing up his neighbor's yards. How do we know that? First, where are the pictures of the damage done by his truck tires? There's no evidence of that. Second, there's no evidence neighbors complained or reported destruction. Third, there's no evidence of landscaping material or other material on the underside of his truck. How could this be with a deep, perhaps watery drain? I think the evidence was conflicting. Drainage ditch running along much of Burford. Again, the context is key. I believe counsel for one of the McMichaels pointed the same thing out, basically. How hard can it be to evade and elude someone who can't go off-road without doing more damage than the neighbors would allow? There's no evidence from the truck's computer system. Roddy Bryan, again, is either the smartest guy in the room, or I guess he's just the luckiest guy in the world, because when he speaks to Minshew on the scene, and later to Lowry, Detective Lowry, that Sunday afternoon, he has no way of knowing whether that information has or will be preserved. There's nor is there any evidence that Roddy Bryan tampered with it. Certainly, you can't blame him that law enforcement waits several months to pursue that evidence. There's no evidence that Mr. Bryan deleted or edited the video from 223 either. We know he couldn't, practically speaking. He watched it at the same time as a police officer. Where is the physical evidence on the roadway of Mr. Bryan's aggressive driving? Where are the tire tracks, the brake marks, the skid marks? For all the times Mr. Bryan supposedly has stopped short or changed direction so that he doesn't destroy anything. There's simply no physical evidence of aggressive driving. What about the lumber in the back of the truck? The evidence shows it's still in the back of his truck afterwards. There's no evidence that any of those timbers went through the back of his windshield. No evidence Mr. Bryan had to drive back around the neighborhood picking them up. No evidence of damage to the bed liner or the tailgate. I don't believe there's evidence of even a scratch attributed to all the acrobatic maneuvers implied by the state. I'm not sure there's even a picture of the front of Mr. Bryan's truck in evidence, but if there is, I'm sure Ms. Dunikoski will provide it for you. Nobody's been looking for that evidence because there was no crime to investigate. There are no witnesses. Nobody will testify that they saw Mr. Bryan drive aggressively or recklessly. No neighbors will testify to that because it didn't happen. We have a neighborhood chock full of security videos. None of them catch this aggressive driving. What does the medical examiner tell us? The medical examiner testified extensively in this trial. He testified, I believe, that the pickup truck could be a deadly weapon, depending on the manner in which it was used, and that's consistent with the charge this court is going to give you. But what evidence is there that Mr. Bryan did, in fact, injure Mr. Arbery? I don't recall there being any testimony of any physical injuries to Mr. Arbery attributable to Mr. Bryan's actions. The cause of death was gunshot. let's talk about the fingerprint evidence for a moment. The fingerprint or palm print is at the driver's side door on the side of the pickup truck. Mr. Bryan points this out in the minutes after the shooting to Officer Minshew. There are no prints or cotton fibers on the front of the truck or on the back of the truck. Now, last I checked, unless you're a Hollywood stunt person, maybe a veteran of Fast and Furious, Tokyo Drift, you're not in control unless you're out of control. I think that was the trailer for the movie. Absent something extraordinary like that, we know that pickup trucks don't move sideways. We also know, when I said earlier there was no witness, we have a witness, and that's Travis McMichael. Travis McMichael testified about the events of 2/23/20. Travis McMichael did not testify to aggressive driving on the part of Roddy Bryan. Travis McMichael testified, I believe, to Mr. Arbery attempting to get in Roddy Bryan's vehicle not once, but twice. Carjacking is a felony. Attempted carjacking is a felony. You will be charged on what attempt is. But the point here is that the objective evidence is not that Mr. Bryan was engaged in aggressive behavior. The evidence is that Mr. Arbery was. And I don't say that as a measure of disrespect to Mr. Arbery. That's just what the testimony is. And I think the state questioned that. I could be wrong, but I could remind the jury, I believe during the testimony of Special Agent Jason Sechrist, during that testimony, I believe I specifically referenced page 54 of that transcript. There's a time when Roddy Bryan is testifying and he says, he's coming back at me and I'm like, oh, blank, excuse me, again. And I started a kind of evasive action, which we see on the video, and dropped the phone. So long before Mr. Bryan has any reason to believe that anybody else has seen this, he's provided that information. Getting a look. What time is it? Oh, okay. Getting back to Mr. Bryan's statements, as I've indicated before, context is the key. It's not what the words Mr. Bryan's using. It's the truth, the meaning that he's attempting to convey with them. And I think I may have used the example before. If I were to say, I ran into your ex in the parking lot at Walmart, you wouldn't assume I ran them over, although technically you could interpret the words that way. There are a lot of words that we use. When we talk on this coming weekend, when Bulldog fans talk about wrecking tech, we don't actually expect that they will. It's a figure of speech. And again, through the examination of these officers, we see that the words that the state has taken have been taken out of context. We see that they've been juxtaposed in inappropriate ways to suggest a conversation that was different than it was. But I can tell you remember this discussion previously, so I'm going to truncate that discussion by pointing out the obvious. 3 police officers interview Roddy Bryan. They don't Mirandize him. They don't tell him that he's under investigation, because he's not. At the time of all these interviews, Roddy Bryan is a witness. At the conclusion of the Glenn County Police Department report, Roddy Bryan is still a witness. Roddy Bryan may not be careful with his words, because Roddy Bryan's never been told anybody's looking at him. But the bottom line is this: 3 good, solid police officers that you heard testify, all interview Mr. Bryan. All of them write written summaries of their reports. I think I went through the 5-page version of Mr. Sechrist. I think I went through the versions of the other officers, not the transcripts, but their actual summaries. 3 police officers who know exactly what they're doing interview Mr. Bryan. None of them interpret his words to suggest that he committed an aggravated assault. None of them interpret his words to suggest that he was involved in any false imprisonment. None of them hear that in what he says. And I would humbly suggest to you that if 3 police officers interview Mr. Bryan for what turns out to be a total of hours, okay, you remember we had an argument about how long the transcripts were and what that would mean. I don't care how you break it down. 3 experienced police officers interviewed Mr. Bryan. None of them summarized for their superiors that Mr. Bryan attempted to run over Mr. Arbery, attempted to strike Mr. Arbery, or attempted to imprison Mr. Arbery. It's not there. And if that isn't a reasonable doubt on count 7 aggravated assault, I just don't know what it would be. Before I leave count 7, I do want to discuss lesser offenses. I'm not really sure why we call them lesser offenses, but that's what we call them. With respect to the aggravated assault count, with respect to Mr. Bryan only, the court is going to charge you on 3 lesser offenses. 2 of them are pretty much garden variety. One of them is a traffic offense. We'll leave those for your consideration. The 3rd one I do want to discuss, however, that is reckless conduct. We don't see that one as often, so let me take a minute and discuss that. In reckless conduct, that offense is committed when a person commits reckless conduct when that person endangers the bodily safety of another person by consciously disregarding a substantial and unjustifiable risk that his act or omission will cause harm or endanger the safety of the other person. and the disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise. I would suggest to you that Mr. Bryan did not consciously disregard a substantial unjustifiable risk in operating his motor vehicle. We would submit to you that Mr. Bryan did not commit any offense in the operation of his motor vehicle, but this is before you, and if you decide that you believe Mr. Bryan's guilty of that, then Mr. Bryan will have to live with the consequences. We have 2 counts left, and Your Honor, I'm getting a look, and I don't know whether that means
From whom?
I think the jury might want a break. It's there. That's up to them. Head shaking, no. Okay. Well, then that's the answer. Sometimes when people are shaking their head, you don't know what they mean. All right. Sometimes people are shaking their heads. Yeah, he's crazy. I get it. All right. Let's talk a little bit about false imprisonment. Mr. Bryan never denied following Mr. Arbery. Mr. Bryan has never denied, quote unquote, angling his vehicle ahead of Mr. Arbery, although he did not use the words in the first interview as the state had suggested. He did use that word subsequently. Mr. Bryan's never denied blocking Mr. Arbery's path of travel. He's never denied cutting in ahead of Mr. Arbery. He's admitted that he did that several times, but as to exactly how many times or where or when, I believe the state acknowledged in their opening that they really didn't know the path of travel. It is essentially speculation. But what we've shown you, I think, at this point is that although Mr. Bryan did all those things, that's not a false imprisonment. Among other things, Mr. Bryan with his own vehicle can't do that on his own. And we know that the McMichael vehicle has gone back down to Tilla to Zellwood and all the way around, which is why Mr. Arbery is alone there for key parts of this encounter. All right. The court will charge you on the law with respect to false imprisonment. This is count 8. The McMichael attorneys have already gone over this in some detail. I'll try to avoid that same ground. First, where there is no confinement, no detention, there can be no false imprisonment. That's the law, pretty basic. Mr. Arbery never really stopped. He never submitted. I think the state's position was that Mr. Arbery resisted to the end of his life. And in saying that, I mean no disrespect to Ahmaud Arbery. I do not wish in any way to lessen the magnitude of this tragedy. I'm simply applying the relevant law to the facts. I'm going to use a different example to kind of illustrate the point I'm trying to make. I try to be humorous at sometimes the humor is not successful. If it's not, please don't hold it against Mr. Bryan. To illustrate the point I'm trying to make here, let us consider the classic example of a bank robbery. A man with a gun enters the bank and yells, "Get down on the ground. I will shoot." There are 3 customers in the bank. The first is a lawyer. The second is a school teacher. The third is a college freshman listening to music, texting a girl, and late for class. Now, instead of getting on the ground, and before the robber can even finish his thought, the lawyer foolishly asks, "Hey, don't I know you?" The lawyer gets shot. He instantly dies. This is murder or felony murder. However, this is not false imprisonment. The second customer, the school teacher, says, "Please don't shoot me. I have children. I'm taking a busload of kids to the museum." She gets on the ground. The school teacher has complied with the robber's commands. She's shaken but otherwise okay. The school teacher, she has been falsely imprisoned. The third customer, the college freshman, for whatever reason, ignores the bank robber. The college freshman says nothing, but runs out the door just as fast as he can. He never looks back. When his parents call later that day asking how he's doing, the college freshman doesn't even mention his near-death experience. The college freshman, although certainly fortunate to be alive, has not been falsely imprisoned. Likewise, in the case before us under Georgia law, I would respectfully submit to you whatever other crimes may have been committed that day, Mr. Arbery was not falsely imprisoned prior to his tragic death. And Ms. Dunikowski may see things differently. For reasons that should soon be clear, she may contend, remember, under Georgia law, she always gets the last word, that Mr. Arbery did somehow submit in the last moments of his life to a combination of the harsh verbal commands of the McMichael defendants, if they did so, and the brandishment of the shotgun, if that happened. That's not exactly the way I recall the evidence, but I would submit that there's still no false imprisonment here as a matter of law. Why? Please look more carefully at count 8. Mr. Bryan is not charged with falsely imprisoning Mr. Arbery with either verbal commands or guns. That is not how the indictment reads. It alleges that Mr. Arbery was confined and detained, quote unquote, using said pickup trucks. The Cobb County District Attorney, I would suggest that you should hold them to that language. Nor does count 8 allege that Mr. Arbery was falsely imprisoned on Burford. Count 9 alleges an attempt to commit false imprisonment on Burford. We'll come back to that. Count 8 does not allege that Mr. Arbery was falsely imprisoned on Burford. Now, that may be where the state contends that Chase started, but the indictment alleges that false imprisonment with pickup trucks happened on Holmes. The state contends that what you see on the now, that's what the state contends you see on the now famous video. We'll come back to that. There are several legal principles we should review before I move on. Again, I think I've discussed this. Abandonment is a defense to the charge of false imprisonment. And I think I've been through that, so I won't torture you with that again. We're getting there. Things I've already covered, I'm not going to repeat for you. All right, trying to find. We've covered that. All right. Attempted false imprisonment. In count 9, Roddy Bryan is charged with attempted false imprisonment on Burford Drive. He's not charged with attempted false imprisonment on Holmes, only Burford. There are reasons for that, but they're really not relevant to this discussion. The court will charge you that in order to commit the crime of criminal attempt to commit false imprisonment, the state must prove intent to commit false imprisonment, because that's required to be a party to the crime. In other words, to prove an attempt, which is what is known as an inchoate crime, the state must show Mr. Bryan's specific intent to falsely imprison Arbery. In other words, for the attempt charge, Mr. Bryan would have to know that the McMichaels with whom he had not spoken lacked probable cause. Now, whether you ultimately determine that the McMichaels had probable cause or that Mr. Bryan had it on his own, there obviously was some considerable testimony about his trailer being taken, something taken out of a family member's truck. He had indicated he got the security system because of concerns. He had heard a bunch of stuff at work. But specifically with respect to the McMichaels, because he's not spoken to the McMichaels, he can't have the specific intent to help them falsely imprison Mr. Arbery. It's just a quirk of the law that he can't be convicted on that basis. Now, almost done. When I go home this evening, 174 St. Clair, I will be sleeping soundly for the first time in a while, because this case hopefully will have been submitted to you by then and my work will be done. Ms. Dunikowski is going to get the last word. I ask yourselves to ask the questions that I will not be able to. Please don't allow any more cheap shots. No more gotcha moments in this case. You will recall the state, I believe that was Ms. Dunikowski, playing the video of a utility truck stopping at the English residence, and the guy jumps out to use the porta potty, which was relevant to absolutely nothing other than Ms. Dunikowski's desire to reinforce for you the fact that Mr. Arbery was dead. That was clearly inappropriate. It was what I call a gotcha moment. And I would submit there's already been too much of it. You know, we've had professional witnesses come in here trying to tell you who you should believe. Again, please no more cheap shots in closing. And then, of course, we have the state talking about the death penalty for theft, for which they were admonished by the court. Now, I'm not trying to rub it in, but I would suggest to you that given all of the cheap shots and all of the misstatements, I won't say they're knowing, we won't be jumping any assumptions, but given all the cheap shots in this case against Mr. Bryan, I would hope that when Ms. Dunikowski has the last word here, that you will hold her accountable and that you will not accept or tolerate any more cheap shots when I have no opportunity to respond. Again, I'm going to posit these 3 questions to you. When did Roddy Bryan know the McMichaels brought guns? When did Roddy Bryan know Travis McMichael would shoot Mr. Arbery? And at that point, what could Roddy Bryan possibly have done to stop it? Mr. Bryan put his faith in the Glenn County Police Department, and then he put his faith in the GBI. He put his trust in law enforcement. He put his trust in our government to do the right thing by him. His trust was not rewarded, and now he finds himself before you. We place Roddy Bryan's fate in your hands. We ask you to return a verdict of not guilty on all counts. I ask you to send Roddy Bryan home. Thank you.
Go.
All right, thank you, counsel. All right, ladies and gentlemen, we are going to take a 15-minute recess. We need to work through some scheduling issues and figure out where we are, and we will bring you back out for a continuation of the case or other announcements in about 15 minutes. Thank you.
All right for the jury.
So we're going to go ahead and do that just so that there's no issues with the panel and whatever may be going on outside. So that's one. Two is I did address the panel, indicated to them that the state believed it had about 2 hours of argument, that the court would still need to charge the jury before we got into deliberations, and in all probability that charge would occur tomorrow. I left the room, asked that they go ahead and notify the court where they were, and the note that I got back is we would like to leave. So based on that, I'm going to go ahead and break for the day. I'm going to start a little bit earlier tomorrow, so gain a little bit of time. So I'm planning to start at 8:30 tomorrow morning. I'll start at 8:30 tomorrow morning and continue with closing arguments at that time. Anything from the state?
Nothing from the state, except I was informed that this coffin situation that Mr. Goff was talking about did not have the defendants' names on them. They actually had the names of Mr. Arbery and I think George Floyd on them. So for the purposes of the record, and I didn't see this personally, I was informed by my people that it was misrepresented of what names were on these coffins that were being shown outside as if it was somehow the defendant's names, and that's not the case, is what I've been informed, just for the record.
And I did ask the sheriff if that was the case. I haven't seen them, and so I'm only relying on what I'm being told, so I wasn't going to spend a lot of time on the record, but it's consistent with what I was told. Again, I didn't see them. There's nothing before the court. I'm just basing this on representations made by counsel and what I've been told by the sheriff's department.
In addition, I only have one other issue that I think needs to be taken up at sidebar, if we could approach about that at some point.
Is it substantive logistics? Because with the defendants, is it something I need the defendants present for? Why don't you talk to counsel before we do it?
Yes, I can talk to Mr. Goff about that.
Okay.
And counsel about that.
Okay. Why don't we, when we break, then let's hold the defendants and let counsel discuss whatever needs to be discussed.
Thank you, Judge.
See what happens.
One last thing, when their jurors are leaving today, if there is this commotion, I expect you've got this all covered, but.
And discuss with the sheriff's department, and there's a plan in place so that, to my satisfaction, I don't believe there will be any issues.
Okay, and so that you and I are using the same idea when we talk about issues, surely that I understand that their safety would be protected. Will they actually be aware, however, of what's been going on as they leave?
Let's go ahead and talk about this
In chambers?
All
right, great, thank you, Your Honor.
On that note, Your Honor, the issue that we have is making sure that the record is clear that they have heard or haven't. That's number one. Number two, that they don't feel like or are made to feel like they're in danger by ushering them into internal rooms, which I understand is necessary, but I worry that the act of doing so creates an issue. Maybe that's not me honest.
So when I walked in, I could hear some noise outside. It's muffled. You can't really hear it, but I was listening for it because it was the first time I've been in that room during really the proceedings. Okay. I heard something and did in fact say, "Oh, have y'all been hearing this?" And the response was, "Oh, we just heard that." That's it. So no, and it's muffled. You can't actually hear what it is. You just hear there's a commotion. What I heard was just it. Apparently, right as I went into the room, a group went around the side of the building. So it was on my radar, and just for the record, heard it. And no, it is not. It is not. I understand the concern, and I'm understanding where we are with the case. I thought I'd put it on the record simply to say, here's what we're doing. But no, they're not being moved because there's a commotion outside. They're being moved because I thought based simply upon that and me hearing that, it was in the best interest of the court to go ahead and put them into one of the courtrooms interior. Thank you.
Also, if the court could put in place something to prevent during deliberation, people walking around the courthouse. It's not a necessary feature of the First Amendment that they walk on all four sides of the courthouse to make their First Amendment speech heard and known. If we could keep them on the front, if the court could do that with the sheriff's department, we would ask that you do that. We just think this is a tipping point issue for the jury if there's any chance of them hearing that or seeing that.
I'll think that through. Candidly, Mike, I have some concerns about doing that. Only that any action of the court or the sheriff's department generally is met with some type of a reaction. And I don't want to do that. I don't want to create problems where there aren't any. It's just a matter of this afternoon, there was a group that walked around the courthouse and I could hear it. That's one thing. If it is something different or becomes much more significant, then I need to figure out how to address that and make sure that there isn't an issue with the jury. I'll go ahead and do that. Understand the concern, though. I think I've worked through the McMichaels and Mr. Bryan.
No, Your Honor.
Okay. All right, I'm going to bring the panel in. I'll dismiss them for the day, and then I'll step down if council could discuss whatever you need to discuss, and then let me know if there is something we need to do on the record before the defendants. If not, it sounds like I probably need to meet with you all in the back anyway, based on the questions that were asked by Ms. Hogue. Okay. All right, let's get the panel.
All right, beautiful people. We have made it through closing arguments for the defense. We'll have the rebuttal tomorrow. We are on normal time tomorrow. We on regular time tomorrow. So we're gonna start up at 9 Central, and we'll be streaming. We'll be streaming a good portion of the day tomorrow. So I appreciate everybody that rocked out with me today, because I did have a late start and I had to stop to go to the dentist. But everybody came back and continued to watch with me. So I appreciate y'all. We'll be back up tomorrow. I hope ASAP Rocky got a jury selected today, because if they did, then we could start that trial after we get done with this one. But if not, I got something lined up for us to do. Remember, if you have any requests to do any rewatches, or if there are any trials that are coming up that you want us to watch together, all you have to do is drop your request in the comments, because we circle back around and get it. Hello, I'm just getting on. Who's on trial? Well, then this was the Ahmaud Arbery unaliving. So Jackie Johnson is also seat in a jury, and she is the DA who was called from the scene of this crime, who's actually on trial for interfering with this trial. So that is the actual trial that we're waiting to start. But in the meantime, in between time, if ASAP Rocky starts, or if ASAP Rocky starts before she does, we're kind of watching stuff in between time. So I hope that made sense. I feel like I kind of said that in a confusing way. Anywho, I think you all get what I'm trying to say. Yes, y'all, I got my tooth fixed. Okay, new tooth. Who is this? Hello, it's the insurance. So yeah. But anyway, y'all, I will holler at y'all tomorrow. I'll see y'all tomorrow. We'll be back 9 a.m. sharp Central Time. So make sure you like, subscribe, and turn your notifications on. Have a good night, y'all.